bringing truth with no tricks.
All right. Probably turned off the wrong one. Mm, mm, mm. That girl's a hot mess. So you know I'm gonna do it again, just because I can. Hold up a minute. I'm so mad. Hold up. Wait a second. Let me go to this other screen. Good morning out there. I know some of y'all is a little bit perturbed with me. You could be perturbed. Um, Hold up. Where is da 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 day da 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 day? Because I don't think I have that set yet. All right, let me see what it did. All right, so we don't like that. That's not right. So we're gonna do that one more time because I'm gonna have to just do editing. But we're gonna get this right. Hold up a minute.
Uh, uh, Here we go, here we go, here we go. Welcome to the show, you know. Monica Mo, justice in the mix. Bringing truth with no tricks. Mama Mo, here we go. Welcome to the show, you know. Monica Mo, justice in the mix. Bringing truth with no tricks. Saturdays our day to shine. Focus on books and storylines. Courtroom drama commentary. Keeping it real, never scary. More justice, dropping wisdom. Weekend vibes, you can't miss them. Open your mind, let the truth be told. From the cases big to the bold. Deep dive into legal scenes. Breaking down what justice means. Analyzing every clue we find. No stone left unturned, no mind left blind.
All right, so that one I know we got heard. Okay, so boom, where's Mo at? There she is. Good morning and welcome to Mo Knows featuring me, Monica Mo Justice. Okay. All right. So I'm gonna tell y'all. I gotta get right into this because I was in my fifties all weekend. So I came up with this idea of how I was gonna present my evidence to you guys, right? How I was gonna have my conversation with you guys, and then I saw somebody do something similar, and I was just like, ugh, I hate this YouTube. I hate it. Nothing could be unique. Like I don't want to be in this. So I like had a whole spaz out moment about being genuine and original. And I'd go through that, right? I'm a Leo. We do that. We take pride in what we do, how we say things, how we see things. So I was feeling a certain kind of way. All right. But I'm going to do it anyway because when I reviewed my position, I always like my positions better. Uh, Hold on, let me see if this is even. I don't even know if y'all heard all of that. I'm over it, but I'm messing with the chat this morning. Okay, there we go. All right, so hopefully the sound transcended and you got to hear what I was going to say. So I need to do one more thing before I could get this. I don't know why it's doing all this crazy stuff. I've never seen all of this stuff before. So let me see if I want to. I think I'm going to share. If I could see this screen, I'm going to share that screen. Okay. But I need to go to the presentation and I need to change. I will not be talking about YSL, the YSL trial with the Roman numeral 2, not a number 2. Some days I just don't understand things, but so I'm gonna leave that one too. I'm gonna hide that one. Today is closing statements or closing arguments, however you want to put it. All right, I'm gonna move this one though. All right. I'm gonna give y'all homework, cause I got some homework out there. Wait a minute, let me say, hey, I'm her. Hey, Shay. Okay, I got some homework for y'all to help me with because I don't understand and maybe y'all know. So I'm gonna start with that one first, and then I'm gonna go into maybe I will talk about the plea deals. I am. All right, hold up. Maybe I should just do the whole damn daggone thing and just stop it. All right, hold up. Unhide this. Let me come back up here. Let me unhide all of these guys. All right, we're just going to do what we was originally going to do. And then I'm going to focus on what today's focus is. Does that make sense? Hopefully that makes sense to you because I'm trying to make it make sense in my head. And because of that, all right, so let me go to OBS again and let me just put a new source in here. It's going to be a browser. Okay. Is that a browser? Ugh, it might not be a browser, y'all. You know what? I'm gonna have to go over here and see if it's a browser. No, it's not a browser. So you know what? We're gonna have to back out of that one. Hold up, I can't do a browser. So boom. This is gonna get removed. Hold up. I think it's gonna be a window. That's the window. That's what it's gonna be. Okay. All right, so 1 second. Let's see how that. Oh, I don't even know how that's gonna work. Oh, that's how that's gonna work. Oh, baby, you so sexy. Oh, hurt them all. Don't hurt them all. Don't hurt them. Don't hurt them with the. Oh, don't hurt them, girl. Oh, I don't even know what to say for my soul. All right. Oh, this is so good. Y'all not even happy for me. Okay. All right. Let's do this like Brutus. Okay, that's how that's supposed to look. Let's turn that off. All right, girl. All right, y'all ready? Are y'all ready? Let me go find my other screen. Hey, underrated. How you doing, JT? What's up? All right, here we go. So folks was running around town I mean, I think I'm a little bit tired also just watching the commentary coming out of here because I think that every day that I've seen the trial so far since the Woody days, right, that people have just been regurgitating the same narratives over and over again. And it's been weighing me down because I just wish that I wish I would hear more thoughts going on for the few channels that I do listen to that are giving you their own insight, how they feel about it. I just be like, yeah, I see your point. I see your point. I raise you one. Um, that's how I be seeing things. All right. But everybody don't see things like I see things. I get it. I get it. All right. So here we go. So as y'all know, next week, yeah, is it next week? Yeah, next week is going to be December something. So next week the Judge Witt is going to be addressed. She's holding a hearing for the remaining defendants in this case. Oh, I should have mixed this up a little. So this is just the original trial began in November 2023, and it looks like it may come to a closure in November 2024. So it's amazing that opening statements began at the same time or around the same time that closing statements will be done. So hold up a minute. All right, so let's see. See how this works out, girl. You get to do everything yourself. Let's see. Okay. All right. Okay, so who's left? I watched the video that was on June 28th of the status hearing for the remaining defendants. And these were, so on the next few slides, next 10 slides, including this one. So for the next 9 slides, maybe it's the next 10 slides because I'm going to talk about this one. But these are the remaining defendants, and this is what happened at that status hearing. Miles Farley was represented by his attorney, and he is in the indictment. He is charged with counts 1, 49, 50, 51, and 54. We know that count 1 is the RICO. Count 49 is the death of Mr. Drinks. 50, 51, and 54 are all associated with, I don't even want to say, because I think that's all associated with how he was apprehended at the home of Jeffrey Williams, but don't quote me on that. So at that hearing on June 28th, he was on bond, and I believe he continues to be on bond. His plea, he rejected the plea offer that was provided by the he rejected the plea agreement presented by the prosecutors, and he is awaiting trial. So he put in his further notice to the trial calendar. In terms of same hearing, Demikian Garlington, he's charged with counts 1, 40, 42, 43, 49, 50, 51, and 54. As you know, 1 is the RICO, and 49 is the death of Mr. Drinks. So his attorney, by his attorney, he rejected the plea. His attorney requested to continue the negotiations, and he was informed by the judge that any negotiations beyond that date, June 28th, would be considered non-negotiated. So we all know what non-negotiated is. At this point, by what happened to Jeffrey Williams. So the reason why I'm pointing that out is because this could come up again. So he submitted further notice to trial calendar. Khalif Adams counts 1, 40, 42, and 43. So what I want to point out is when they got counts, I feel like it is more it's more weighing on jurors that if they find you guilty of counts for, if you got an account outside of number 1, that means you're going to trial for this thing that's before us, and it's easier to associate count 1 if they have to look at additional counts for you. It's easier to be found guilty of count 1, in my opinion. Okay, so he also rejected the plea and further notice to calendar trial. Damone Blaylock. Now, this is interesting because he too rejected the plea. His attorney motioned for reconsideration of motion regarding the severance of his client without consent. So this dude, if you even just heard the argument that he made, and maybe on another date we'll present this, but the judge basically said to him, "Yo, homie, you submitted it in writing, and I'm denying it." So then he's tunnel vision, just like the prosecutors. He had tunnel vision. And he was just like, he just re-argued the whole issue. It really didn't make no sense. His primary concern was that his client was sick on one of the hearing dates and was conveniently severed from the case. And he didn't give his consent to be severed. And he felt like he should have proceeded with the original case. So what that says to me is that he wanted to be on the other case because he felt like the other people would probably get off. I don't know what he was thinking, but he didn't consent to being severed. So the judge denied the motion now for 2 times. He denied it he denied the written motion, and he also denied the oral argument that the judge didn't consent to in the first place. That the attorney just asserted himself in there and did it. So he moved on to he too further notice to trial calendar. And as we know that in November 2024, should be a comma there, Brian, still on appeal, argued before the Supreme Court that the trial, the murder of Holmes, had reversible error. It's going in and out. Let me move away from it. Thanks for that update. Let me know if it clears up. Okay, then there is Mr. Fleetwood. He's just charged with count 1, which is the RICO. He did not, his attorney was not present in court. Plea negotiations were held open due to the absence of a counsel. So I'm putting this on the table to just say that the reason why there's probably a status hearing, because we know that Judge Witt is pushing plea negotiations or plea deals. So I could see her wanting to touch or circle back on some of these open plea negotiations and set a new timeline for them to do some reconsiderations. And after having now tried the first case, she probably has more leverage with the prosecutors to enforce that they should be doing more plea. Demise McMullen, he's charged with counts 1 and count 2, and count 2 is the murder of Donovan Thomas. And interesting enough, now that I understand the mindset of the prosecutors, they started this. Thank you very much. They started this. They started this chain of events, right? Their timeline begins with not the origins of how the gang in and of itself was incorporated, right? How it became a gang, right? It starts with the act that the gang participated in, which is which they allege is the murder of Donovan Thomas. But when you look at the overt acts, it begins before the murder of Donovan Thomas. So anyway, this guy is represented by Asian, and his name I believe is Ming Lim. I'm a little bit off of the tape. At that time in June 28th, and the reason why I'm pointing out that this is an Asian, that he's Asian representing him, is because there's a cultural thing here, right? And do believe me, there's gangs in the Asian community as well, but there's a cultural thing here, which I heard a snippet of it in the trial recently. But in any event, that's the attorney. He at that time did not have discovery, had not been turned over to him. So this is in June. The attorney pledges that to do his best to get ready for trial, and his plea negotiations also remained open. Bradford Jarvis. All right, he's charged with counts 1 and 2. His attorney might be Aisha. Again, I was just listening. Maybe I picked it up wrong. But he submitted further notice to trial, so I'm assuming she rejected his plea too. Justin Cobb. He recently had an attorney appointed to him, but no plea offers. But he was appointed. Okay, so this one is interesting because this dude didn't even know really who he was supposed to be representing. So he was there. He answered the roll call for another defendant, and then he had to be told that he was representing this defendant. So I don't know if he got it together, but overall, this is the defendant that's not in custody at this moment, or could be in custody. If you listen to the attorney that was representing him, he believes that he is in the system, or was last in the system at Washington State Prison with no release there. So he was assuming that that's where his client was at, that the state had not conveyed a plea offer to him, so he could not give one to a client, and moreover, he doesn't have a client right now in custody to have a conversation with. And so that's Justin Cobb. Tanquarius Menda, counts 1. Oh, hold up. Justin Cobb, let me just go back. He has counts 1 and 2, which means that he's also in the new gang, in the new grouping that is alleged to have participated in the MDK of Mr. Thomas. All right, Mr. Menda, he has counts 1, 44, 45, and 46. He too rejected the plea, and he has further notice to trial calendar. Jimmy Winfrey, counts 1, 24, 25, and 26. His attorney at the time, June 28th, filed a leave of absence. Defendant would like to fire that attorney and retain his own attorney. Don't he sound like a little Woody to you? So because his attorney sought a leave of absence, his plea negotiations were held open. I didn't do the count, but we can go back later and count how many plea negotiations are open. But I feel like all of these plea negotiations are still on the table, because as of June 28th, what's his name was still the judge, and I don't think he was recused yet. So these would be the first hearings these people have after removal of Judge Glanville from the underlying case. Now, when I looked through the sheet, I noticed that there were three defendants who were who didn't take a plea as of June 28th, who were listed on the indictment in the re-indictment, and had not taken a plea, nor had they been listed as one of these men at the trial. So that was Cordarius Dorsey, Christian Eppinger, and Jaden Myrick. All right. So based on my information and my little bit of research that I did, that I'm depending on you guys now to help me understand what does this mean and where is he at and what is the status of him in this case. So Dorsey was convicted in September 2023, right, of all 10 counts in the January 2020 shooting of Xavier Turner outside a College Park barbershop. Now, that's all I got. I didn't go into depth to see if Mr. Turner is a MDK victim or if I didn't go into all of that. All right. But it also said that Dorsey was already serving a life sentence without parole after he was convicted in 2019 in connection to an armed robbery in MDK of this dude, Jala, 39, a husband and father of 6. So that can't be Turner. So maybe he did that in 2019 and he did the other thing in January 2020, right? He was involved in these two shootings. And then in 2023, he, I don't know. But that's what I found out about him. More to come. But he's on this RICO, so uncertain if he's included in. That's me. I'm uncertain, so I just need clarity. If anybody knows what happened to this dude, hit me up in the comments and let me know. Okay, Christopher Eppinger. So it's been brought to my attention by listening to other YouTubers that he is definitely on the he's included now with the 10 that I just listed above. But until I see that, the information that I had was that he was severed from the case, and that was that. So I don't know if he's supposed to be on the other case. You know, they seem not to have their paperwork in order in this place. Myrick Glass, he was removed from the YSL RICO case after being diagnosed with schizophrenia. So I think that's the dude that was up there MDK and Pete, or trying to get at YF and Lucci in the jail. Okay, so to date, these are all the defendants. Oh, you know what? I should have did that one name at a time. All right. Anyway, these are the defendants that have taken plea agreements in this case. So we have Arnold Greer, Huey Beebe, Murphy Stevens, Lee Sledge, Greer. Oh, I got him twice. See the mistakes you figure out. Williams, Sumlin, Ryan, Nichols, and Kitchens. Who was the goofy they booted from OG7? Demikian? What do you mean? Who's the goofy booted from? What's the OG? I don't know. Girl, don't get me started. I gotta update my slide. I don't know. Your pee-pee? Who? I don't know. I don't know who that is. Okay, so now let's get to the things that are going down today. The charges against Yak Gotti and Shannon Stillwell. Okay, for Demonte Kendrick, who is Yak Gotti, right? So going into this, he had counts 1, 2, 57, 58, 59, 60, 61, 62, and 63. We know that during the what do you call that thing? Ooh, what is that thing called? Directed verdict. Mm, I don't know. I guess we're just gonna have to wait till we get to that day and see what number actually comes out because I don't know. Um, so Demikian, Demonte Kendrick, right? Yak Gotti, um, is now before this. So the charges that the present jurors will be considering is count 1, 2, 57, 58, 61, and 63. Now, I did not look through the numbers that were over here to see which one of these are supposed to be um, which one of these is supposed to be a 133 that's changed to a 131, which means that it's got the lesser charge or so. I don't know which one it is. But moving on, we know that count 1 is RICO. Count 2 is the murder against Donovan Thomas. So this is what the current jurors will be considering today, and this is what the evidence that the prosecution, which I hope they do a better job tying this evidence together in their final. I don't want to be hopping through stories listening to them finalize what happened here. I hope that they have taken the time and taken the weekend at least to corroborate with each other, collaborate, and come down with a more streamlined story. So that's it on that. There's no gun charge related to this. Like, it is so weird that just with this murder of Donovan Thomas, there's no subsequent or consequential counts to go with it. Like, that's it. Perhaps when they were charging us, they should have looked at it as a conspiracy to murder, and maybe they would have gotten a little bit further. But here it's just the murder with no information on it. Just that charge is just going to be the malice murder of somebody. They're going to have to meet all the elements. And it's very interesting because everyone that's charged with count 2 is also charged with shooting him with the firearm. Well, at best, there were several bullets on the scene, and we seen people in the barber shop shooting back. So how do they even identify bullets? I think there is a Nibin match on one of them, but today we'll get to the bottom of it. Count 57 with the offense of participating in a criminal street gang activity. So when I get to count 49, I'm going to explore that just a little bit differently because personally, I think, I'll take it right now and just say this. I feel that if if Yak Gotti and Shannon Stillwell are not found guilty of counts 2 and counts 49, respectively, of how they're charged, the feds are going to come in and recharge this. Reasons I say that basically surround the fact that Blaylock filed this appeal, and the Attorney General came out and did a brief of its own on the situation. So I feel like um, I feel that someone will retry this with the same information, but on a federal level, just because they feel like it was the incompetence of the DA's office to charge. So I don't know why I just have that feeling, but I hope I'm wrong. So I want you to pay attention to this because I heard different statements being made about these counts, right? And why they should or should not be here, still remaining here. But we'll listen to Doug's closing argument and see how he purports on count 57. But this gang activity is associated with the arrest on May 9th. So this is at Thug's house. And it's the possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, and the possession of a firearm during commission of a felony as alleged in counts 58, 59, 60, and 61. I don't know how this stands when some of those counts, right, 59, when some of them was taken away, but yeah, so you see like 50, 58 is still there. 59 is not there anymore. Um, 60 is not there anymore. So at least whatever 59 and 60. So I'm just going to go. Normally when people do this, right, so I'm assuming that 58 is marijuana. 59 is the cocaine. So this should have been cleaned up. And I would think that that Doug Weinstein would address this so that the count is clean. um just because it's murder and it's not it wouldn't be so let me correct myself. It would be something like the civil rights violation of Donovan Thomas, a civil rights violation against what it would be something along that level for the murder. If it went to a federal, if it went on the Fed side of things, they find different charges in their statute so that people wouldn't say that it's double jeopardy. But everything we're seeing in this case stinks of double jeopardy, but not really, because when you really break down what RICO means, right, that racketeering influence, if you really look at what its intent and the poor argument that the poor lawyering in terms in quoting the judge, the poor lawyering of this group of prosecutors, RICO is it's when you take what has happened and you say that, listen, this stuff all happened because all of these little activities that just make no sense and these are what people were doing were for a bigger cause, and this is why we're charging this. So no, we're not recharging them for what they did that they already did time for. We're charging them now because those things was part of a bigger scheme. That's what that is supposed to be about. Counts 58, violation of the Controlled Substances Act, again with the possession of marijuana with the intent to distribute. So when I look at this, I'm like, the judge kept these in because she's saying, listen, I don't got no evidence to say that DeMontre Kendrick was had all this cocaine and codeine and et cetera, but I do have some kind of belief that he might have had this marijuana. Now, I don't know how she had that over the other stuff. Maybe it's just an assumption that folks who are in this way of life are also, it's more likely to be involved with marijuana. Maybe his past history had a record of marijuana, that it's more than likely that he was involved in the marijuana component of it. But I still missed when I looked at the information from the information or the testimony provided. I didn't see intent to distribute really. It didn't stand out for me. So this would be another count that I hope that when Doug is doing his closing arguments, that he is more focused on. Tomorrow I'll come back with this slide and we'll evaluate how he argued this to the how he and the prosecutors argued these counts to the jurors in hopes of getting a guilty or not guilty verdict. Count 61, with the offense of possession of a firearm during a commission of a felony for the said accused in Georgia. So this was interesting because I believe that this was still one of the firearms found in Jeffrey Williams' house, right? So what they're basically saying is that there's a propensity here that if someone is possessing marijuana with the intent to distribute, that in order to protect themselves in that line of business, that they would be in possession of a firearm during the commission of that felony. Good morning. Count number 63, with the offense of possession of a firearm by a convicted felon previously convicted of a felony involving the use and possession of a firearm. So 61 is possessing the firearm to do the business of 58. 63 is the violation of having said firearm because you previously was convicted. So with that being said, again, I believe that his attorney Weinstein's arguments against these charges is going to be critical. Let's move on to our friend Shannon Stillwell, SB. So now we've learned only through the marriage certificate that SB stands for Shannon Bernard. And that's how he got his name, SB. So the counts here that he's facing is 1, 2, 49, 50, 51, 52, 54, and 64. We all know that number 1 is the RICO. Number 2 is the murder of Donovan Thomas. Number 49 is the murder of Shamel Drinks. Here goes where you finally have some kind of connection to the murders, right? As in terms of charges. So count 50 is the participation in a criminal gang activity, which was to wit the murder of Shamel Drinks, right? And this is very important. Let me see. Let me come back. I don't think I got highlight on this, but very important. If you get down to this point, an associate. So they're saying that in this count 50, to find him guilty, you have to find that he participated in this activity to murder Shamel Drinks, right? Because Shamel Drinks was an associate of a rival gang, right? The only way that they show us that he was an associate of the rival gang is that when upon his death, the opposite gang, the rival gang, posted tributes to Mr. Drinks, and that's how they associated him with being an associate of the rival gang. That's ludicrous to me because they had, when their gang detectives was out there, they could not identify him, the decedent, in the vehicle because he didn't have any known affiliations. When they ran his fingerprints in their little fingerprint system that they brought out there and put his little fingers on there, right? His deceased fingers. They did not determine at that moment that they was dealing with somebody who was an associate of the rival gang. They said it wasn't until the post came out on the social media accounts that they were able to make a connection between him and the rival gangs. So, as alleged in count 49 of this indictment. Okay, so now moving on to number 51. So we know that count 50 is saying that he was in a gang, or what they're alleging is that he was in a gang, and not he was in a gang, but the gang activity resulted in the murder of Shamel Drinks. That means like we were in this big rivalry and we got one of theirs. So now here we go. Count 51 is in furtherance of that activity. It's saying with the intent to maintain. So it's still gang activity. So this count is saying with the intent to maintain or increase their status or position in the aforesaid criminal street gang. So basically, how do we get to that? How do we get to that distinction? They're basically saying that because this guy is an associate of the rival gang, and by murdering him or causing the death of this man, it helped them maintain their status in their gang. This is the first that we, beyond count 1, where they talk about how the gang was doing things in furtherance of YSL and protecting the YSL empire. This says with intent to maintain or increase their status or position in the aforesaid criminal street gang. I didn't see any evidence of really defining Shannon Stillwell's status in the YSL criminal street gang. But we did see evidence presented that he asserted himself when incarcerated not to be attacked by other gangs in there. You know, that whole conversation with the what's the weather today, or whatever that conversation was about. So I found it interesting that they didn't zero down and specify that it was YSL in this charge, but just said criminal street gang, period. For all we know, Shannon Stillwell, based on the information that has come out in the trial, could have been a participant in a number of different gangs other than really being down with YSL, other than it being the music label and that being the business that was about to pay him for his talent, not for his street abilities. Number 52 is the possession of a firearm by a convicted felon previously convicted of a felony, which is when they made the arrest of him. And well, actually that's not what that is. That is so here this charge is for the 14th day of March. So if you find that he committed number 49, then you could opt to say you could find him guilty of 50 or 51, depending on if you find him guilty of 49, you could still consider 50 and 51 and come with a not guilty or guilty, or because this is related to the street gang activity. But count 52 is basically tied to count 49, because if you don't find him guilty of 49, then he can't be guilty of 52 because they go together. Those go together. The 50 and 51, well, 50 will go if you find him guilty, and this will be very complicated for jurors, because you can find him guilty of the murder, which I don't even think anyone can based on the videos that we saw. But I do have some commentary for that. That's beyond this. 54, with the offense of possession of a firearm during the commission of a felony. So this is also for the murder of Shamel Drinks. So this is linking him to having the gun. And so he shouldn't have had the gun in 53. And then in 54, you're saying that because he had the gun and he was doing the felony, this is a charge for that. 64 is with the offense of possession of a firearm by a convicted felon, previously convicted of a felony involving the use or possession of a firearm. So this is the day of the arrest, because it's the 17th day of March, and this is the gun that he discarded. So that's a whole different, another gun on a different day. So that summarizes all of the arguments that we should be hearing today. So get your point cards ready, because these are the things that the focus should be on when you're hearing the prosecutors making their case. But more importantly, these are the counts that you're going to hear the defendants' attorneys speaking on, and really trying to hone in on why there should be a not guilty for each of these charges. Okay, so I gave you my thoughts on how I felt about if someone should be charged in these what could be the next steps in terms of charging. Let me see if my notes are here. Hold on a second, because I don't think these sync up that quickly. Okay, let me go back to my laptop. Just a few thoughts on the Shamel Drinks murder that I wanted to share with y'all, because that's the one that bothers me the most when I'm looking at it. All right, so some YouTubers this weekend decided to go back down memory lane and share Shard's opening statements. And I decided to take a deeper dive into the opening statements, or I was listening with my other ears. And this is what I heard. So, Shard's opening statement, during his opening statement, he mentions that Stillwell was in the car with Garlington. So he's basically confirming what the district attorney has brought out, that Garlington was in the car, because we saw no evidence based on the videos that Garlington was in the car. So the only thing that, and remember, his opening statements of any of these attorneys and closing statements, closing arguments of any of these attorneys is not evidence. It is just them providing a narrative around the evidence, but it's not evidence in and of itself. So Shard mentions that Stillwell was in the car with Garlington. So that's basically corroborating the story of the district attorney, who they say that Garlington was in the car, although we saw no evidence of Garlington being in the car, and Garlington was on the phone. Now, in Shard's open statements, he also indicated that in Nichols' car only there was Miles Farley. Now, although we all saw Miles Farley exit the car from the passenger back seat behind the driver, and re-enter the car from the passenger's back seat, we could reasonably conclude that there might have been a passenger in the front seat. The DA puts a passenger in that front seat and says that he made the call. Monica's position is, if we're led to believe, and Shard mentioned no way of this person, but the prosecution, who has Garlington on the phone with him, right? Here's what's the anomalies. The prosecution did not charge that person that was on the phone that they believed that the two cars were calling each other, but that person was in the car. I contend that the person was not in that car, that person might have been in the third car. And that's why Shard decided to not mention him at all. He's absent from the opening statement from Shard. He's absent from the opening statement, but he's integral. He's not charged by the DA at all in this case. So the question is, why isn't he charged if he was sitting in the same vehicle that you charged Nichols and Farley for being in, with the full knowledge that even if they was in that car, that they did not participate? But then how could they not have participated? Because they would have then still got the gang charge, because when you're in the vicinity of something that happens, then you're still liable for you still have liability for what happens as you being in concert with. So this just doesn't make any kind of sense when it comes down to the other person on the other end of the phone. And I didn't have the time to go back to listen to what that person was saying when he was on the other end of the phone and wait up, catch up, whatever. But I still go to my position is that car number 1 and car number 2 were not involved in the actual shooting of Mr. Drinks. But I am still not convinced that they do not know who was in car number 3. And I'm not convinced that the prosecution doesn't know who was in car number 3. But maybe because car number 3 is dead and stinking on another murder, they probably just say, hey, let's not charge him. But that's just an accusation. I don't like to make unfounded accusations here, but definitely my thoughts are open. I'll be back later this morning to cover the trial live, streaming it on my end, depending on how I feel about it. But I'll be around. I'll be around. Yeah, I think that summarizes my notes. I just don't like the whole drink situation. Anyway, I'm gonna bid you people a good day. This is Mo, and I've got to go. Oh, I didn't do that other thing. Oh, did I download it? Hold up. I don't think I downloaded it over here. I gotta download it over here. I didn't. All right, I'll do that tomorrow.
Turn no mind left blind. served thoughtfully. Books and cases join the ride. Monica, more justice by your side. Oh, justice dropping wisdom. Weekend vibes, you can't miss them. Open your mind, let the truth be told.